Divorce legally unties the knot of a relationship, but separating a family's financial life requires an entirely different set of tools. While a divorce application changes a couple's legal status, it doesn't automatically divide their bank accounts, pensions, or real estate. To do that, the legal system relies on a dedicated mechanical pipeline to force the equitable redistribution of assets. This pipeline is governed by Part 9 of the Family Procedure Rules 2010. Part 9 dictates exactly how financial remedy claims are managed in the courts of England and Wales. This strict procedural code mandates every specific action taken by practitioners and their clients. The system is designed with a singular objective: to force total financial transparency between the parties, thereby increasing the odds that they can reach a negotiated settlement before a judge has to make a ruling. To achieve this, Part 9 structures the litigation into a linear sequence of 4 mandatory phases. High-stakes emotional disputes are volatile environments where spouses might try to hide assets or ambush each other in court. A rigid, step-by-step pipeline removes that chaos, replacing it with a predictable timeline where every piece of data must be accounted for. The pipeline begins by formally initiating the financial claim. This first step requires a specific document: the Notice of Intention to Proceed with an Application for a Financial Order, universally known as Form A. Form A can be issued within the initial divorce proceedings or filed later as a standalone application through the family court's online portal. However, the timing of this filing is subject to a severe statutory constraint found in Section 28.3 of the Matrimonial Causes Act 1973. This timeline shows the risk. If a divorced individual remarries before filing for financial provision, they are barred from applying for capital orders against their former spouse. This is the remarriage trap. Form A must be lodged before any new marriage. Securing the claim in the court's queue is the prerequisite for everything that follows. Without filing Form A, no financial negotiation can safely begin. Once the claim is active, the pipeline moves to the disclosure phase. This relies on Form E, an extensive financial statement where both parties must detail their entire financial history, current resources, and future needs. Under Family Procedure Rule 9.141, both sides must sign and exchange their completed Form Es no less than 35 days before their first scheduled court appointment. The court mandates absolute, full and frank disclosure. Every bank account, property, pension, and liability must be laid bare and supported by hard evidence. The House of Lords case Livesey v. Jenkins established exactly how seriously the courts take this requirement. If a party conceals material facts, the entire foundation of the legal settlement is compromised. If an order lacked full and frank disclosure, the court can set it aside completely, forcing parties to start over. But there is a corresponding risk for parties who suspect their spouse is hiding assets and take matters into their own hands. In the case of Emmerman v. Emmerman, the Court of Appeal drew a hard line against self-help evidence gathering. Spouses and their representatives are strictly prohibited from breaking into personal files, copying private hard drives, or retaining confidential documents belonging to the other party. The procedure operates on a strict balance of power. The court guarantees that it will force the opposing party to disclose their wealth, but it will punish anyone who attempts to vigilante their way to the truth.
With the raw financial data on the table, the pipeline arrives at the first court hearing, the First Directions Appointment, or FDA. This hearing exists purely for logistical case management. The judge is not there to decide who gets the house or how much maintenance should be paid. To keep this hearing efficient, the courts require the legal teams to prepare Form ES1, a joint document that outlines the agreed timeline of the marriage and a summary of the exact legal issues in dispute. They must also file Form ES2, which is a joint schedule of assets and liabilities. Instead of the judge cross-referencing 2 separate Form E statements, Form ES2 forces both parties to consolidate their claims into a single unified spreadsheet that highlights exactly where their valuations disagree. At the FDA, the district judge reviews these documents to identify missing information. They issue binding directions to fill those gaps, which often includes ordering joint expert valuations, like instructing an actuary to value a complex pension.
If both legal teams can agree on these directions ahead of time, they can submit a draft order using the accelerated procedure and bypass physical attendance at the FDA entirely, saving their clients thousands in legal fees. The FDA acts as a procedural funnel. It takes chaotic, contradictory raw data and organizes it into a single, judicially managed battleground, preparing both sides for the most important phase of the pipeline. That phase is the Financial Dispute Resolution, or FDR, hearing. The FDR is the court's primary mechanism to force an out-of-court settlement before a costly trial becomes inevitable. To facilitate honest negotiation, the entire hearing operates under a strict without prejudice rule. This privilege guarantees that any offers or compromises discussed during the FDR cannot be used against either party if the case proceeds to trial. Because of this, the judge plays a highly unusual role. Instead of making a legally binding ruling, they review the consolidated ES2 data, listen to the arguments, and provide an expert indication of what a court would likely order at a final trial. To protect the integrity of the process, a vital procedural safeguard is enacted. Because the FDR judge has heard privileged negotiation details, they are permanently barred from presiding over any future final hearing in that case. The legal system intentionally manufactures this privileged, highly pressurized safe space. By giving the parties a preview of their likely fate in a confidential setting, the court motivates them to settle the matter themselves, saving vast amounts of judicial resources. If the parties cannot reach an agreement and draft a signed consent order at the FDR, the pipeline moves to its final stage. Before proceeding further, the rules dictate that both sides must file open proposals. This strips away the without prejudice protections, placing their exact demands cleanly on the public record. This paves the way for the worst-case scenario node, the final hearing. At the final hearing, all negotiation ends. A new judge takes control, applies the substantive law, and dictates the distribution of assets, taking the decision out of the parties' hands entirely. The Part 9 pipeline filters cases away from this outcome. Form A starts the clock, Form E reveals evidence, FDA organizes data, and FDR applies pressure. The data flows linearly. A failure in disclosure mathematically corrupts every downstream calculation. Mastering the rigorous procedural mechanics of Part 9 provides the only safe path for legal practitioners to deliver their clients to a secure resolution.